You have the plea form, Your Honor?
I do.
Good day,
Hello, what's your name?
John Michael Punch.
All right, Mr. Funch. The plea form that I have indicates that the defendant will be pleading to an added count two, a retail fraud in the third degree, the 93-day offense. On a successful plea, count one would be dismissed. That's the entire understanding of the.
That's correct, Your Honor.
May I have him sworn? Is that correct, Ms. Counsel?
Yeah, yes, sir. I'm just having trouble pulling up the plea form, but I'm sure that's right.
It's okay. Let's have him sworn.
I believe you.
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I sure do.
State your name.
John Michael Punch.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would be your maximum fine. You understand that?
Yes, I do.
All right. And understanding all of that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on March 5th, 2025 at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan? What did you do at the Home Depot that makes you think that you're guilty?
I had a tire to return and I kind of just returned it myself and it was a $20 difference, the price. And I just walked out with the tire.
You had a
A
tire?
tire for my wheelbarrow
Oh, okay.
was dumb.
And so
He purchased a tire at $39.
Right.
It didn't fit, so he brought it back into the store. And rather than waiting and doing the exchange with the customer service, he selected a $59 tire.
is that all correct, sir?
It is, yes.
So, and then when you selected the new tire, you did that and you walked out without paying the
I did,
difference?
yes.
And you knew that's what you were doing at the time?
Yes, absolutely.
All right. You didn't have anybody's permission at Home Depot to do that, did you?
No, not at all.
And the item that you took out that was priced at the $59, that was an item that they had offered for sale?
They did, yes.
All right. Counsel, have I complied with the court rule? Well, sir, I do have to advise you that if between the time of the acceptance of this plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, won't happen again. Yes, I do.
And also, sir, any recommendation or evaluation by the court would no longer be entitled.
Yes,
The court would no longer be bound by. You understand that?
yes, I do.
All right. Second, I'm checking. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 noon.
October 22nd, 2025, 12 noon. Sir, looks like you have some other issues here.
No?
Well, I'm not,
Oh, sure.
Mr. Allen.
You don't have no warrants?
No, I don't. Yeah,
Right, I've got two warrants. And I've got a warrant, which this is an old case because it has a 97 case number on it. And it was transferred from our original case management system into the new one. I'm not sure why it appears the way that it does, but it's a civil case. But for whatever odd reason, has a 5,000 10% bond on the case. And they issued the bench warrant. It was a Samuel Hall Jr. versus John Prince. I don't know why that, when I'm looking at the case, there may have been, oh, I know why. All right. There was a subpoena, and I'm having to piece it together, but there was a subpoena that was issued. You didn't appear to court. Ultimately, at least my procedure was there was a show cause and then a bench warrant because you didn't appear.
Does it show he was served though, the subpoena?
I'm not,
I didn't know
there
that.
was a point at which there was no service. I do see that on here, but then they filed a new subpoena. Discovery was filed, and at a later date, then the bench warrant was issued. So I have to assume that the bench warrant was issued. That was, although it's a 97 case, because I took over that docket, I'm listed actually as the judge of record in that case. But I would not be the one that would be handling it now. What I'm gonna do in that case, because it's so old, on that one, I'm gonna cancel the bench warrant. All right. And then I'll just indicate that they need to reset before Judge Barr, who's handling our civil docket. You have another civil case that's from 2020. And the plaintiff, and it's a civil matter, is a Suzanne Riesel. I don't know if you know that person versus you. In that case, again, it appears the same thing, except in 2023, a debtor's exam was scheduled before Judge Barr. And on April 18th of 2023, you failed to appear for that debtor's exam. The judge issued a warrant.
Was notice returned or?
I have no idea. I'm just looking at the file or at the
Hold on.
printout. I would suspect that if notice were returned and Judge Barr knew about that, he would not have issued a warrant. But a bench warrant was issued on that. A bench warrant, for whatever odd reason, even though it was in April, was then issued October 10th of 2023, and it's gone through this year in February. The warrant was valid.
May I have case numbers? Because we don't have access.
I canceled the one,
Okay.
one case number. The one that there's a valid, let me just give you, one case number is 97-2C3143. That's the one that I canceled the warrant on. The other one is 2004 C0243. both of them, it appears, come from small claims matters.
Your Honor, is
Um,
there an address in the 243? I'm trying to make sure you got notice of all this.
in the 243, there's the address of Parker Road, but I don't know when the warrant and everything came through, whether or not that was, no, I'm sorry, it's not Parker Road. It's Outer Drive. It's the same address that I have on this case.
So I'm asking the court to not take him into custody, but
It's a valid warrant. You're gonna have to address that before Judge Barr. That's his warrant that was issued on the civil case. It's a cash bond only warrant from his failure to appear for a debtor's exam.
But, Your Honor, I'll be brief. As the court knows, we don't have access to JIS. Usually we'll run our clients' names through JIS and have the benefit of at least alerting our clients to warrants.
Right.
Without access to JIS, and I interviewed him in the court, I interviewed him in the interview room, he wasn't aware of any warrants. That's why I was asking about the addresses and whether he had properly been served the subpoenas or served with notice of those debtor hearings. And so because I don't have JIS, I can't help him.
I will straighten it out.
Well, I understand. And Mr. Brown, I appreciate what you're saying. I think it's what has transpired is just crazy regarding JAS. I don't agree with any of it at all. I think certainly to those that have asked, I've expressed that. This is the one danger that happens. People get locked up because you guys who do a fantastic job don't have the benefit of being able to get open access to the information that's contained in the case management file. It's an abomination. I do consider it. If you raise the issue, it may be a violation. I'd have to look at it as an individual's due process and constitutional rights, because I have to do what I have to do here. But the court itself, quite frankly, is impeding your ability to do that. Something's wrong. There's going to have to be a ruling on it if it's raised. So you are more than free to raise that before me, since I'm the one sending, or raise it before Judge Barr because this is his case. But at this time, I do have a valid warrant. I'm going to take him into custody, sir, so that you know the bond amount that I have here is 2,650 cash.
How much? 2,000?
2,650.
You got that on?
No.
That sounds like on the civil case, that may have been the judgment amount. And then when you didn't appear for the debtor's exam, that became the bench warrant.
What can I say? How do we get a hold of them?
Hold of who?
The people I owe the money to.
But hold on.
Well,
You got to go with the court officer. And if you got a credit card or somebody you can holler at, you can call for the 265. Maybe you can post it.
not 265, 2,000.
Oh, 2,065. No 10% privilege?
It's a cash bond that normally would come off for a civil case.
So you got to go with the court officer. Make
All
some
right.
calls.
Go with the court officer. Mr. Brown, if for whatever reason he's not released, or there's some difficulty, you can't get before Judge Barr to adjust or do something, I will entertain whatever motion you have, because I realize this would not have happened but for what has transpired over the past few weeks.
Thank you, Your Honor.
You're welcome. You only had to post for one bond. I canceled, so that you're clear, I canceled and just wiped out the 97 one. That may come back to be, but it's from 1997, so it's older than I am. I'm not gonna do that.
Well,
You don't have to laugh. You really did, you could have just let that ride.
I'm sorry.
Will JIS reflect the cancellation so that the other court knows?
Yes, because we brought that over from the old system. It's in the JIS system, which you can't get to, but it's in there, and I wrote on there that I'm canceling that one out.
And the sheriff's will know. It'll be canceled.
They will not, because they lost their access to JIS when the court did what it did too. So a whole huge mess has been created. I don't know what they're going to do when they see that I'm putting him in on a warrant. Because to the extent they're able to look up a criminal case, I don't know what they're gonna see the civil. I have no idea.
Can I ask one thing?
I can, yes, you can ask one more question that I can tell you I do not know, but go ahead.
May I have a copy of the cancellation that you put in the file so I can give it to him?
I just wrote it.
Yeah, but.
I can write it on another
So if
piece
he
of paper.
walks out, gets pulled over.
Okay, so here's what the problem is. Yes, I get it, Mr. Brown. The problem is that I wrote cancellation on my JIS printout. Supposedly, you guys aren't supposed to have that. I don't know why. It seems stupid. That's a legal term. And so I can't give you that.
You give to him?
No, I can't. I don't think. I had to think it through. Mr. Brown. I don't know that you guys can even do this. This is also what's weird because you guys represent people on criminal matters. If you were to indicate to me that you're the attorney of record or get him to sign something that they would like that information turned over to you, that's fine. You're trying to get some verification that I canceled that warrant.
Yes.
Because you can't get to the place that it would be. So here's what I will do. Ms. Weidling,
Yes, Your Honor.
could you type up a document for my signature to present to the public defender's office that I can't, on the 97 case that I canceled it, I will sign that, and that way you have it in writing from me.
Yes.
Thank you.
That took much longer than it needed to. Court calls the case, not because of you, Mr. Brown, it wasn't. Just stupid stuff.